On right now and get us started. Good afternoon. My name is David Walton. I am the event and program manager with the Tompkins Chamber. We're very excited today to bring you yet another webinar in our L.E.A.R.N series brought to you by Tompkins Trust Company. Today, we will be focusing on legal issues relevant to reopening during COVID-19. We're very fortunate to have with us today Ms. Celia Bigoness. Celia is an associate clinical professor at Cornell Law School. And with her is Mr. Hoon Lee. Hoon is a third-year law student at Cornell as well. Today, our topics of discussion will be on how to comply with employee privacy protocols while maintaining a safe workspace, strategies to avoid potential legal liability, changing employee status and pay, addressing employee concerns and about returning to work, and visa options for immigrant employees. Per usual, this session will be recorded and made available on the Chamber's YouTube page and on Cornell's website after the webinar concludes. If you have any questions for our attendees that are with us today, please feel free to put those in the chat box. We do have time for Q&A at the end, but sometimes our panelists will pull some questions directly from the chat and address those as they're doing their thing. Celia is no stranger to this webinar series. She's been here a couple times. She's amazing. She's super informative. And without further ado, I'm going to turn things over to her.
Wonderful. Thank you so much, David. And I'm pleased to be here with all of you. And again, thank you for taking the time to join out of what I know is a busy schedule with a lot going on. I'm actually very excited for this webinar because this is the first webinar that David and I have collaborated on that is not just, oh gosh, this pandemic has hit, everything has come to a standstill, what do we do? This is our first really sort of forward-looking, all right, now we are in phases of reopening, we understand things are going to be different, how do I navigate this? So for me personally, that's very exciting. It also, however, as we're going to talk about, is a complicated area, and it's one that's in the news, daily, if not hourly. And so we're going to talk through some of the issues that have been arising and that may arise over the coming weeks as we all proceed through reopening. I'm assuming in the audience we have a mix of businesses anywhere from phase 1 through phase 4 of the New York reopening plan. So this presentation covers all of you if you have already reopened. I think there's certainly tips that you can get from it. And if you are currently planning to reopen, for example, an office worker, we're going to give you some practical advice about how you can proceed. So what I'm going to do is I'm going to share my screen because I have some slides that I'm going to be sharing with you. We put a lot of content on these slides. We are lawyers. We like a lot of words and details. Certainly do not feel as if you need to note down everything that is on the slides. We will make them available to you after the fact. And one thing we've done is we've put a lot of links to relevant government resources in the slides so that you can get the most up-to-date information even weeks from now. So those links should hopefully be a useful tool for you. So as I mentioned, this is an area that is getting a lot of attention and scrutiny these days. You have businesses that have been very, very much damaged by the COVID economic crisis, as you all well know, want to reopen, want to do so wisely and cautiously. You have employees who are eager to get back to work, get back to their paychecks, get back to normal, but who also are uncertain about the risks that might entail. So I've put up here quickly just 3 headlines that were in my email alerts just this morning when I woke up. So these are just 3 stories just from today. One issue that we are going to talk about that was in the New York Times this morning is about to what extent, excuse me, sorry, got a little pop-up ad, to what extent workers are permitted to stay at home and continue collecting unemployment checks if they're currently on unemployment and they are nervous about coming back into the office for a variety of reasons or into the workplace. We're going to talk about that later today. There was a lawsuit that has been filed against Amazon relating to a fulfillment center in Staten Island, and the employees at the fulfillment center allege that Amazon has not been following the protocols for operating safely during COVID-19. McDonald's also is facing an employee suit for not following the COVID-19 safety protocols. So again, this is just a small snapshot of the headlines this morning. We are going to give you as much practical advice as we can today, but I'm warning you, some of our answers are going to be this is a little bit unclear, this is a gray area, and here's what you can do to best protect yourself. Because this is an area where we have a variety of well-established employment laws that have been in place in many cases for decades and decades, which are all being tested by this pandemic for the first time. So what we're going to talk about is, we're going to talk about employee privacy and how you can comply with privacy rules and regulations while also making sure that you're putting in place appropriate screening measures to ensure that employees coming in are not posing a risk to you or to anybody else. We'll talk about how you establish a safe workplace. We will talk about liability concerns and know that a number of employers are thinking, well, what if somebody comes in and one of my employees or a customer gets infected in my workplace? Am I liable to that? We'll talk a little bit about cash flow management, because my understanding is many of you will be coming back with reduced or somewhat changed operations, and many of you have likely taken a revenue hit over the past couple of months. We'll talk about how you manage cash flow. Related to that is how you can change your employee status if necessary, for example, from full-time to part-time or from salary to hourly. And Hoon is going to touch on a few specific considerations for any of you who either currently employ or may be hiring immigrant workers, because that has become a little bit more complicated in the past couple of months because of the pandemic. So without further ado, let's talk about employee privacy. These first couple of slides I'm going to go over very quickly. I'm sure you as business owners are all very familiar with them. Again, we have a well-established framework in our country that has been in existence for decades that protects employee privacy. Now, there are both federal and state laws. We're going to talk in particular today about the Americans with Disabilities Act, which is the federal law, and there's a New York equivalent, which is the state human rights law. Generally speaking, the goal of these laws is to protect confidentiality, ensure that employees are safe from discriminatory questioning or discriminatory actions by an employer. So general principles prior to COVID were that as an employer, you could not make a medical inquiry or require any sort of medical exam of your employee. There are certain exceptions. For example, if you own a moving service, you could ask about whether a potential mover who wants to come work for you is physically fit. If that person shows up and clearly has a physical impairment, you may be able to inquire about that. Obviously, in COVID-19, many of you will want, and in fact, the government in New York and federally is encouraging you to do more, to ask your employees questions, to screen them. I'm at Cornell, and we just yesterday had a long town hall meeting about how we start to screen faculty, staff, and students when they come back on campus. And we're talking about it in September. So this is a reality that's going to be here for a while. So generally speaking, under the ADA, you could not screen an employee or require a medical test unless the most relevant exception is the employee poses a direct threat to you or others in the workplace due to a medical condition. So now the premise that New York State has taken is that we need to assume that everybody is a direct threat right now and then we put in place screening procedures to make sure that they are not, or to do the best that we can to verify that they are not. So specifically, what that means for you is that you are going to be permitted to do certain things, require certain information, collect certain information about your employees that you've not been able to do in the past. And we'll go through that. You still, however, need to make sure that you're complying with the general confidentiality measures that still apply under current law. So, for example, keeping medical information confidential, separate, putting in place password protection, reasonable measures to make sure that you are not compromising anybody's privacy. If you work in a 5-person workplace and all of a sudden one person is out sick for 10 days and you say, we have one affected employee, but I'm not going to tell you who, obviously everybody's going to know. So as a practical matter, just do what you can. All right, so can you require an employee to take a COVID-19 test as a condition to coming back to work? Yes, absolutely. I said we've embedded a variety of links throughout this presentation. There's one here, if I can get my mouse to it, sorry. You'll see I've linked at the bottom to EEOC guidance. The EEOC is the, sorry, my mouse is getting a little tricky. The EEOC is the Equal Employment Opportunities Commission. And they, earlier this month, said yes, you can require employees to take a COVID-19 test. You can do that as a condition to coming back to work, and you could require that test on a regular basis if you want. Obviously, different regions have different capacity to test. Many of you know, testing has been imperfect in our country, to say the least. So the practicality of this requirement certainly is going to depend on to what extent your employees can obtain a test in a timely manner. But you can require a test. For this, like many other issues that we're going to talk about, we don't know how long you are going to be able to do this. We don't know how long this general exception to the overarching privacy laws is going to be in place. There I got my mouse. So this link is one that is constantly updated by the EEOC, taking into account all federal employment laws and how they are potentially changing in the course of the pandemic. So this is a useful link that we've included in several places in these slides for you to get more details. So all I'm going to say here is stay tuned on this. It looks like for the foreseeable future, you're going to be able to require a COVID-19 test if you want. But that will change at some point as the crisis begins to abate and as we begin to assume a footing where employees are not assumed to pose a direct threat. Similarly, yes, you can take an employee's temperature. You can either do it yourself as a condition to the employee entering the workplace. You can require them to do it and report to you. Again, we don't know for how long. New York State is explicitly encouraging employers to take temperatures. Of course, though, it's imperfect. Certainly not everybody who is COVID-19 positive displays a temperature. And I know from talking to a different audience a couple of weeks ago that many business owners were concerned that employees who really need the income and want to be back at work might be doing things like, for example, taking ibuprofen in the morning to bring their temperature down if they do have a temperature. So you cannot rely on this protocol alone, but you absolutely can do regular temperature screens. You are allowed to ask employees if they have had any of the COVID-19 symptoms. Again, imperfect because not everybody is symptomatic, but you are allowed to do that, and you are allowed to require an employee to stay home if they do display any of the symptoms. You can ask your employees if they have traveled to any COVID hotspots. So as you all know, the CDC regularly updates on both international and domestic hotspots. I've got a link here to showing the international ones, and puts out travel health notices, travel advisories. You can absolutely ask your employees if they have gone to any of these places. If you do, just make sure to do it uniformly and in a non-discriminatory manner. You certainly don't want to be asking some employees and not others, but you can absolutely ask. And the same general principles apply to hiring as well. So if any of you have lost any of your employees during the crisis or you are going to be hiring new employees, you can do the same things now. You can require screening, you can require temperature checks, you can delay their start date if they are symptomatic until they get a COVID-19 test, and you can withdraw a job offer if a prospective employee refuses to comply with any of these procedures. So everything that I've just talked about is a huge departure from the employment laws that have been in place in our country in the past couple of decades, and it's going to be evolving as we navigate this new normal. So I've included again here a variety of resources, FAQs, and guidance that will be updated. So as I say, my big question now is for how long you're going to be permitted to have these screening procedures in place, and we just don't know the answer to that. But I would say keep checking back in this space. All right, so workplace safety. If you are in phase 1 or phase 2, you may have already opened your workplace back up. If you are thinking about reopening in phase 3 or phase 4, certainly you are going to be doing so in a far different manner than you operated before. So as you probably all know, again, generally speaking, there are both federal and state rules around workplace safety and providing employees rights if an employer is not providing a safe workplace. The main federal rule that you probably all know and love is OSHA, the Occupational Safety and Health Act. And luckily, we are in a state that generally defers to OSHA. So in some states, you have a complicated state overlay on OSHA. For right now, we generally defer to OSHA. Although there is some specific New York guidance on safety during the pandemic that I'm going to talk about in just a minute. So many of you have probably been following this in the news. OSHA, which is relatively it's not a household name in this country other than for business owners who are very familiar with it. OSHA has been in the headlines though. Since the start of this pandemic, OSHA took the approach of saying, we have such a wide variety of workers, workplaces, COVID-19 incidents, threats, public health situation across the country, that OSHA said it would be impractical and in many cases punitive and unfair to put in place specific prescriptive rules around workplace safety. So OSHA's general approach has been from the start, we're going to use our discretion. We are not necessarily going to enforce our usual health and safety standards. For example, a couple of weeks ago, I spoke to an audience of veterinarians, and many of them had not had their respirators checked by an OSHA representative in the required time period. Periodic checks are required. And OSHA had said, look, we just don't have the people to do that right now. Do the best that you can with the respirators that you can. So I've linked here to a variety of memos that OSHA has issued. You know, unless you want to geek out with us on the law, there's not necessarily anything you need to look at here. It's just to show you the general approach that OSHA is taking, saying we are going to exercise enforcement discretion. The major theme of everything that OSHA has said is we expect an employer to use good faith efforts to comply with our standards. So if face masks are readily available, you should be providing face masks for all of your employees. If hand sanitizer and soap and bleach are readily available, you need to be using them to sanitize surfaces. If you have to wait 2 weeks to get gloves or face masks before reopening, chances are you would probably wait those 2 weeks, right? So OSHA is going to be thinking about what are you able to do with the resources that you have. So can an employee refuse to come into work for fear of getting infected in the workplace or on their way to the workplace? In Tompkins County, again, many people may be reliant on public transport. Certainly this issue is live in areas like New York and Chicago and LA, where a lot of workers rely on public transport to come in. They may trust their employer, that the employer is doing everything right to make the workplace safe, but they worry about getting between home and the workplace. So generally speaking, there is a very high standard for an employee being able to say, I'm not going to come to work, but you need to continue paying me because I'm worried about coming into the workplace. The law says an employee can only do this if they are in, quote, imminent danger. OSHA has actually issued guidance on this issue specifically, and OSHA cited as examples of what an imminent danger would constitute an employer requiring you to travel to a COVID hotspot. So if Cornell asked me to go to Manhattan in early May, medical personnel who are being required to work without PPE. OSHA has specifically said anything short of this very high threshold does not constitute a justification for employees to refuse to come into the workplace. We're going to talk in a few minutes about how you handle this as a practical matter, because obviously, as many of you small business owners, it's not you against your employees. You all work as part of a team, right? And your business is only viable if the team is viable. So we'll talk about how you navigate this, but that's the general legal threshold. So what OSHA has said is employees can't refuse to come into work, but they can file complaints about an unsafe workplace. Right at the beginning, we looked at a couple of complaints against Amazon and McDonald's. But I don't know how many of you followed this in the news last week. The head of OSHA went to Capitol Hill and got really grilled over the fact that OSHA had only taken one COVID-related enforcement action against a workplace out of 5,000 complaints that it received during the first period of the pandemic. So there's a question right now about, is OSHA doing their job properly? That being said, in New York State, there has been very prescriptive guidance about reopening, and we're going to talk about that. So the New York State guidance is probably going to be most useful to you as you move forward and think about reopening, rather than the OSHA general guidance. Okay, so what underlies the concern about employees not wanting to come back is that, in fact, that many employees sadly have been on unemployment, as our country has had historic unemployment highs. I know a variety of business owners say, well, are my employees incentivized to come back? You know, certainly their unemployment checks are not 100% of what they would have received before, But if they are comfortable and safe working at home, if they have others in the home who might be vulnerable, they don't want to come in, will they accept collecting unemployment benefits for longer? We saw the headline in the New York Times that was about this specific issue. So unemployment generally, previously, an employee was capable of collecting 26 weeks of unemployment in any year. Those benefits have been extended to 39 weeks because of this pandemic. And the group of people who are eligible to collect unemployment has also been expanded. So now part-time workers and contractors are eligible for unemployment benefits, whereas they were not before COVID. So many of you may have portions of your workforce that either are or have been on unemployment in the last couple of months. So traditionally, New York, like virtually every other state in the country, has said, yeah, you can collect unemployment as long as you are looking for a job and through no fault of your own, you're not able to get one. So, and I've linked to this general guidance here. What that means is if you as business owners are able to say to your employees, I've done everything and I've followed all the protocols and the workplace is as safe as I can possibly make it, and I want you to come back and here is your job, then technically your employees are not able to refuse to come into work. And if they do, they are not eligible for unemployment insurance. States are differing in how they handle this, just given the massive volume of workers on unemployment right now and the public health situation. It very much varies among states, depending on certainly to what extent they've been hit by the pandemic and the approach that that state generally takes to labor laws and workforce protection. New York, up until now, has reiterated the general standards and has said that the general standards apply. So here are updated FAQs. They're from March 31st, but they have not been changed since then. And I'm going to scroll down. I think the very last question, or near the end, is, oh yeah, so I'm an older worker, I'm immunocompromised, I'm personally uncomfortable about going to work. Am I eligible for unemployment insurance? The general answer is you're not eligible if you voluntarily leave. You may speak to your employer about a reasonable accommodation, which we're going to talk about in a minute. But at the end of the day, what New York is saying is if you are offered a job and if your employer has taken reasonable measures, then you are not eligible to collect unemployment. What is unclear to me right now is whether New York will actually enforce this rule. I think now that we are reopening, we're going to start to see employee challenges. Thus far, New York's reopening has been extremely limited, but I think this issue is going to play out over the coming months. So what can you do as an employer? We are going to talk about specific guidance for ensuring workplace safety. I think what is going to be paramount for you is going above and beyond in communicating to your employees and having a two-way communication. So for you, is telling your employees exactly what you have done to ensure a safe workplace. So citing the specific guidance from New York State for your industry, showing your employees that you've put in place a safety plan. We're going to talk about a safety plan in a few minutes. Being very prescriptive about that safety plan, saying, you know, I'm going to have however many tubs of hand sanitizer delivered every 2 weeks. We have this number of face masks. We are going to be spacing people out at least 6 feet apart, 8 feet apart with these procedures, right? So going into granular detail to show your employees what you are doing. And you know, there's a couple of strategies here. One is so that they know specifically what you are doing, but two is just conveying to them that you have thought about this and you are approaching this in a thoughtful, cautious manner and in a way that is engineered to not only protect your business, but protect your people as well. And also having employees have a chance to share with you their concerns. So we're going to talk about reasonable accommodations. Some employees may say, I'm immunocompromised, or I'm caring for a mother who lives with me and is immunocompromised. Can I work a shift where there are fewer customers in the store? Things like that. And so hearing employees out on their concerns is going to be extremely important to, again, show that you're working together and it's not you against them. I did a webinar a few weeks ago for essential businesses in New York, many of them in New York City, and there had developed a somewhat adversarial tone to the relationship between business owners who needed their people to come in and employees who didn't trust that they could come in safely. And so you want to avoid getting into that adversarial position from the start. So I've mentioned a couple times a reasonable accommodation. Again, many of you are probably familiar with this area if you're already business owners. The general principle being, prior to COVID, if an employee has a disability that might impair their ability to perform their job, an employer is required to make a reasonable accommodation. So if one of my employees is in a wheelchair and I want that person to work at the front desk in my reception area, I need to make sure that there is room for their wheelchair to get around the desk and maneuver behind the desk, right? So for COVID-19, there are certain, as you know, conditions that might make people particularly vulnerable to COVID-19. OSHA has said that there are certain conditions that do require a reasonable accommodation. So if any of your team have pre-existing lung or heart conditions, a significantly weakened immune system, diabetes is another one, then your employees can ask for a reasonable accommodation. Now, the government has specifically said age, pregnancy, or being a caregiver to others who are compromised does not constitute a basis for a reasonable accommodation. Now, that's under law. As an employer and as a manager, you can choose to go beyond what the law tells you to do, and you can accommodate employers who are in that situation, but the law tells you you don't have to. So the reasonable accommodation requirement is subject to an exception that says, if any reasonable accommodation would create an undue hardship for you, then you don't need to provide it. And the government has specifically said, with many businesses being adversely affected by COVID-19, in particular having cash flow reduced, we will take into account the current cash flow situation. We will take into account the available human resources when figuring out whether an accommodation would pose an undue hardship. So, for example, if one of your employees says, I'm immunocompromised and I'd like to work a shift where I see fewer customers, and you have somebody who could swap out with them, then that's a pretty reasonable accommodation. If your employee says, I can't come into the office at all for the next 3 months, that may not be a reasonable accommodation if you don't have the people available to perform that job and you need to reopen. And staying closed because of that employee might decimate your business. So that's the legal framework. As a practical matter, you never want to be in a position of arguing with your employees about whether a reasonable accommodation would constitute an undue hardship. If you're there already, you've gotten to the adversarial part of the relationship. So for that reason, what I'm going to suggest is for any of you who haven't already reopened, certainly start talking to your employees now about both what you are doing and what their concerns are. And it's okay under current law to ask your employees, do any of you anticipate needing accommodations because of COVID-19? So, again, seeking out, do any of your employees have pre-existing conditions? Are they concerned for any reason, right? You don't want to be in the position of reopening and on day one, having 2 of your employees come to you and say, oh, I'm really worried I can't come into the office. So start doing this now. So you can ask about reasonable accommodations. You are allowed to ask certain questions and require medical documentation if you want, all with the intent of not just verifying the condition, but figuring out how you can accommodate it. The EEOC has said that you can put in place temporary accommodations right now for the COVID-19 pandemic and tell an employee, I want to revisit these at the end of July, at the end of August, at the end of the year, whenever, to see if they need to remain in place given the public health situation at the time. The one thing that you cannot do, though, is fire an employee because they have asked for a reasonable accommodation and you refuse to provide it unless you can't provide it without undue hardship. So if it would cause you undue hardship to provide the reasonable accommodation, you can deny it. If it would not, then you have to provide it and you can't be seen to fire or otherwise retaliate against an employee who has asked for a reasonable accommodation. Again, though, my recommendation is never going to be, don't get to the place of arguing with an employee about an undue hardship because you've already put yourselves sort of against each other then. All right, so what if you reopen and one of your employees is infected, or you think an employee is infected and they are symptomatic? Not only are you permitted, but you are actually required under law to send home that employee and to do the best contact tracing you can to figure out who worked in close proximity with that employee. The general guidance, again, is who worked with somebody within 6 feet for a prolonged period of time in the past 48 hours. You can go above and beyond this protocol if you would like, but you should do that. And of course, making sure you are protecting employee privacy as much as possible. Even if you have a small business and everybody's going to know who it is, just don't say the name. Partly, you don't want to ever be accused after the fact of violating privacy laws. And also, you want to establish confidence among your team that if any of them are affected, you will protect their privacy the same way you did their colleagues' privacy. Okay, so many of you may be familiar with the New York reopening requirements. In fact, you are probably very familiar with it as business owners. One thing that I did not know is that in addition to just understanding the rules that apply to your business and having a safety plan in place, you need to affirm your compliance with these rules with New York State before you can reopen. So we'll run through each of these in sequence. So, as I said, New York has been much more prescriptive than the federal government in coming up with reopening guides. So for whatever phase of reopening you are in, you can go to the New York Forward website and find the relevant New York guidance. So for the construction industry, there's summary guidelines, and then you'll want to read the very detailed guidelines about exactly how you can operate. For every industry, New York has put together a specific safety plan template that you are allowed to use for your business, because the second requirement is, in addition to understanding the guidelines for your industry, you need to have a written safety plan. My recommendation certainly is going to be that you share that safety plan with all of your employees. You may consider even posting it for your customers or clients, and you have to be prepared to show it to the government if they ask. You don't need to send it to New York before you open, but if New York asks you for it, you need to be able to produce it. So again, depending on where you fall in the phases, you can get this specific guidance from New York. Phase 3 and phase 4 guidance has not come out yet. Generally, for the past 2 phases, New York issues the specific guidance for covered industries a few days before reopening. If that, sometimes it's a little bit shorter notice. But as we get closer to your phase, you'll be able to find the relevant information. There is also a general safety plan template for any industries that are not somehow covered, although New York has been pretty comprehensive about identifying industries to this point. You are certainly welcome to have a safety plan that is more onerous than what New York requires, that goes above and beyond in terms of the safety protocols. You cannot, however, have a safety plan that compromises in any way or is less onerous than New York's plan. And then finally, once you've done all this, there's a website where you need to affirm to the state that you are reopening and you understand all of the rules that apply to you. Given the number of businesses in New York, is New York going to be enforcing this affirmation? Chances are not, particularly for small businesses, but I'm still going to recommend you do it. And that's not just because I'm a lawyer and I say follow the law. It's because we're going to talk about liability protection in a minute. To protect yourself against future liability, and also to show your employees, look, I'm doing all the right things, it's safe for you to come into the office, you want to follow the letter of the law to a T. And making this affirmation is going to protect you both now and down the road in case you are facing any claims from an employee or a customer or client or anybody who had contact with your business. All right, so for reopening, do I need to provide my people with face coverings? Yes. At a minimum, you need to provide face masks. And depending on the nature of your business, you may need to provide gloves or other PPE. Employees can't be required to pay for this, and you need to put in place additional sanitizing procedures depending on the nature of your business. And this is all written out in those detailed guidelines. But generally speaking, if you're reopening soon, get face masks for your employees. You absolutely can, and in fact, you are required to require your employees and contractors to wear masks for right now. Again, depends on how the rules around wearing masks and social distancing evolve, but for right now, yes. As a condition to coming to work, your people need to wear masks. You can refuse service to customers or others who come into your workplace and refuse to wear a mask. Please make sure you're doing so in a non-discriminatory manner. You're applying the same rules to everybody across the board, but you certainly can make this a requirement of doing business with you. And so here are some general resources. Again, OSHA. OSHA has issued industry-specific guidance. You are going to want to make sure, though, that if you are following the OSHA guidance, you also are looking at and following the New York guidance. They should be consistent in many ways, but you'll want to make sure that you're in compliance with both of these legal structures. So I mentioned a minute ago that, what may be in the back of many of your minds is, okay, so I reopen, I'm doing everything I possibly can, somebody could still get infected. What is my potential liability and what should I do to protect myself? So here's where I'm going to give one of those terrible lawyer answers of it all sort of depends on the facts, but it very much does. But I'll give you some practical tips here. So I would imagine that all of you have workers' compensation insurance in case workers need to make compensation claims. The general premise of the workers' comp system is that an employee doesn't need to show who was at fault. They don't need to show that you were negligent and your negligence caused them to fall off a ladder or whatever the claim is. They just simply need to show that they have incurred an injury or a disability in the workplace and want to claim compensation for it. And that's why you all have your workers' comp insurance. So there has been some guidance, some federal guidance on workers' comp claims in COVID-19. Generally speaking, for an employee to make a workers' comp claim against you if they contract COVID-19, they need to show that they contracted COVID-19 in the course of performing their job, not at the grocery store or elsewhere. For healthcare workers, this is presumed. For others, though, they're going to need to pass that threshold. And the second threshold is they need to show that they got COVID-19 because there was a risk in the workplace that was not present elsewhere. So what that means as a practical matter, sorry, I have a lawnmower outside. I can close the window. This is what happens when you're working from home. So as a practical matter, what you need to do is follow all of the guidance that has been prescribed for your industry. At the very least, follow it. You could potentially go above and beyond. Because then, even if an employee can say, I went straight between work and home every day, I didn't make contact with anybody, and nobody in my home has COVID-19, so I must have contracted it in the office, they cannot make a comp claim if they cannot say that you created a greater risk than the risks posed to the general public. So if you followed all of New York State's guidance to a T, and all of your team followed that guidance to a T, then it's going to be extremely difficult for your employees to make a workers' comp claim because you did not create any undue risk by having them come into the workplace. They simply encountered the general risk that all of us face these days whenever we leave the home. So this is kind of like the unemployment insurance area, one where there are very strong opinions on either side. Workers' advocates, labor unions, all say this workers' compensation system is too onerous in the context of COVID, and it's going to be too difficult for anybody to make a compensable claim. Employers and insurance companies say, worry about being overwhelmed by workers' comp claims if the standards are lowered for making a claim. So as of right now, a workers' comp claim due to COVID-19 seems somewhat difficult to make. That could change, however, if the standards are relaxed. Putting aside workers' comp, as a lawyer, my worst nightmare is a tort claim. So if many of you don't know the word tort, that's fine. Think of it as slip and fall cases. Or the customer who went to McDonald's, ordered a coffee, and sued because her coffee was scalding and burned her skin, right? So the basis of this type of a claim is you were negligent in something you did, and your negligence caused me harm. So here, the basis for a claim by any of your workforce or others who came into contact with your business, customers, clients, suppliers, their basis for making a claim would be you were negligent and you did not protect me in the way that you are required to protect me, and therefore I contracted COVID-19. What's scary about tort claims is, unlike workers' comp, the amount of your potential liability is potentially almost infinite. There could be compensation damages, punitive damages. But the good news is negligence is a pretty high threshold to prove if you are doing everything to follow the federal and state guidelines for reopening. So if you are being reasonable, making good faith efforts, following the guidance, then it's going to be extremely difficult for anybody to prove negligence. So that makes it extremely important to please have that written safety plan in place. Make that affirmation with New York State. Document everything that you are doing. So if employees are required to do temperature checks when they come into the office in the morning, have those temperature checks noted down somewhere and note what each person's temperature was. If you're asking your employees to clean their workstations before they leave for the day, have a checklist where employees can check off and say, yes, I did the cleaning that you asked me to do, right? So do all of these sort of simple measures, be overly cautious in documenting what you are doing, and that will be a very solid basis for refuting any claims that might be brought against you. Hopefully you won't be in that position. Okay, so cash flow management. Many of you I know have suffered potentially drastic reductions in cash flow due to COVID-19, or possibly even a cessation in cash flow altogether. And as you reopen, you're going to face certainly some initial reopening costs, and you may not be able to reopen at full capacity, whether because of industry restrictions or because you have small children at home and need to care for them while schools are out, or a variety of other reasons. So how can you manage your cash flow during this time? As many of you know, both New York and the federal government put in place new enhanced paid leave for employees either who are sick or quarantined themselves or who have family care obligations due to COVID-19. In many ways, if you shut down your business, this paid leave has not been terribly relevant for you, but it will become more relevant as we reopen. So again, I have linked to a variety of sources you can look at. In the interest of time, I'm not going to go through this paid leave in enormous detail, other than just saying it's very specific to the size of your business and the circumstances of a claim by an employee. So generally speaking, if an employee is able to perform all their job duties from home, if they voluntarily traveled to a COVID hotspot and contracted COVID there, they're not able to claim paid leave. So under New York paid leave provisions, if you have fewer than 10 employees and less than $1 million in revenue, you are not required to provide any enhanced paid sick leave to your employees beyond what you are already providing. The amount that employees can claim basically rises with the size of the business. And again, you can follow the state guidance on this. I've just broken it out into a somewhat simple table because the details are mind-numbing. For employees who are not quarantined or sick themselves, but are taking care of minor children, again, there is compensation, there is paid leave. It's at a somewhat lower level than for employees who are sick themselves. But there is compensation, and it applies if a child is healthy, but their school is closed. And many of you, like me, have been in this position for the past couple of months and may continue to be for at least portions of the next academic year. If a school voluntarily closes, then your employee is not eligible for leave. But if the school is mandatorily closed, then you are eligible. Now, one thing that the federal government has done that New York did not do is the federal government put in place an exemption for small businesses, saying, if you have fewer than 50 employees, we understand that providing this onerous paid leave for every employee who's staying at home because a school district is closed, could decimate your business and potentially end your business. So if you have concerns about paying employees who need to stay home with their children, you can apply for an exemption if you meet the fewer than 50 employees threshold. And again, you'll have to consider that as a strategic and financial matter for your business. Employees also have certain paid leave benefits under New York law if they are taking care of a family member who has COVID, just like if they're taking care of a family member who has cancer or has had debilitating surgery, right? Now there's a federal overlay as well, the Family First Coronavirus Response Act. So the FFCRA covers all businesses with up to 500 employees, excuse me. But again, you can ask for an exemption. It's in place for the rest of the year. And just like the state guidance, it provides sick leave and family medical leave for employees. Again, there are enormous details that go with it, which is why we provided you with the links. Generally speaking, an employee is not allowed to double dip, however, so they can't claim all the federal benefits and all of the state benefits. If the FFCRA provides an employee slightly more than New York State does, then you have to pay the amount mandated under the FFCRA. Conversely, if New York is more generous to the employee, you pay the New York amount. So for the most part, they overlap, but there are some discrepancies, which is why we provided these links. You may or may not already know about certain tax credits that are available to you to help navigate your cash flow situation. So if you have been paying sick leave or family care leave pursuant to either the FFCRA or the New York State rules, then you can claim a tax credit for 100% of the wages that you paid during that time. What makes this tax credit even more valuable is you don't have to wait until year end to claim it. You can claim it on a quarterly basis as you are paying your payroll taxes. So you could use the credit to potentially reduce the payroll taxes that you owe to zero. And even beyond that, if the credit that you receive is actually more than the payroll taxes you're paying because you have potentially a reduced payroll, you can actually get a check back from the government. And if you're self-employed, you have similar benefits. So again, I've given a link to the IRS sites for both businesses and self-employed individuals that you can look at yourself. Another tax credit is for any businesses that were shut down and continued to pay their workers. Many of you may have been in this position, whether you took one of the Paycheck Protection Program loans or simply paid workers out of your existing cash. If you paid your workers during this time, and you can show that in any quarter, your gross receipts compared to 2019 were cut in half or more, then you can get a tax credit for half of the wages that you paid during that quarter to any of your employees. So again, this is going to be a highly valuable tax credit, I would expect, if you have kept any of your employees on payroll. And New York has just recently put in place what's called the New York Forward Loan Fund. You may or may not have heard about it because it's quite new. The basic premise is we understand that businesses are going to be incurring a lot of expenses as they look to reopen, both the general expenses of going in and cleaning and starting up a workplace again if it's been shuttered for a couple months, and the particular expenses of putting in place social distancing measures and acquiring PPE, all that sort of thing. So the Forward Loan Fund is basically a working capital loan to fund those reopening costs, both the general costs, obtaining inventory, and the specific COVID-related costs, for example, purchasing PPE. So you are eligible for this loan if you are a small business, you're running a small nonprofit, or you are a small residential landlord. And I've put the criteria on the slide here. Unlike the Paycheck Protection Program loans, these loans are not forgiven. They are 5-year loans with interest. The interest terms would be, I believe, are negotiated in a case-by-case basis. Also, unlike the PPP, Paycheck Protection Program, which quite infamously ran out of funds and then had to be refunded, these loan applications are not considered on a first-come, first-served basis. Instead, New York is looking to spread the loans out regionally. So the southern tier gets 4% of the state funds available, and they are going to be prioritizing industries and regions that have reopened. So what that means is right now you are in a prime position to apply for this New York Forward Loan Fund, whether you are in phase 1, phase 2, or even phase 3 or phase 4. So I don't know how long it is going to take New York to process these loan applications because this fund has just started, but time is of the essence, and I would imagine that the applications will be processed very, very quickly. All right, and sort of part and parcel of cash flow management is that you may have to change your employee status. You may have previously full-time employees who are going to go to part-time. You may have salaried employees and you can't pay their full salaries anymore. You want to reduce them to hourly. So generally speaking, if you're reducing your employees' hours, for those salaried employees or exempt employees who are exempt from minimum wage and overtime, you have to pay the full salary for any week in which that employee performs any work at all. If you expect a 40-hour work week and that employee performed 1 hour of work because your business was shut down or significantly shuttered, you still have to pay the full salary. That's different from hourly workers. For hourly workers, non-exempt employees, you only pay for the hours worked, unless, of course, you've agreed in a contract with your employees to do something different. So how can you reduce pay given these circumstances? You are entitled to reduce both salary and hourly pay at any time. You have to give notice to your employees, and I'm going to recommend you give that notice in writing. But you are allowed to do this subject to minimum thresholds set out under law, both for salary and for minimum wage. One thing you can do, though, short of reducing salaries for your exempt employees, is you can require your employees to use their paid time off and their vacation days during periods where your business is slow and there isn't enough work for your employees to do, so that when business reopens, they're able to come back and they don't have that accrued vacation for the rest of the year. And you can change your salaried employees to hourly employees. Doing so is complicated because, of course, you make them all of a sudden eligible for minimum wage and overtime. If they were previously salaried, they probably work hours that go beyond overtime requirements. So you want to make sure you're being careful about this. But that is a way to reduce your payroll costs at a time when your employees may not be working to full capacity while your business is reopening. So I have done a lot of talking. I'm going to hand over to my colleague Hun, who has been doing a lot of immigration-related work at the law school and focusing in particular on how immigrant workers are affected by the COVID-19 situation. So he's going to talk you through a few considerations if you do have any immigrant workers on your workforce. All right, thank you, Hun.
Thank you, Professor. As Professor Bigoness said, employees on temporary work visas could face some immigration issues due to COVID-19. Now, this is a murky area because we could see like new immigration policies in the upcoming weeks, but there are some guidance in place right now that will allow employers to keep hiring and employing foreign workers. Next slide, please. So first, there's this temporary guidance that allows employers to process I-9, employment eligibility verification, remotely. Employers do have to inspect some of the documents remotely via fax or email, and also timely obtain those copies and record COVID-19 as the reason for delaying the required physical verification. And in-person verification must be completed within 3 days after resuming in-person normal operations. Now, employers should mark I-9 documents as documents physically verified and then dated, because documentation issues can arise and be grounds for a termination of these immigrant visas. So documentation is particularly important with these documents, even though there is guidance in place to allow remote verification for now. Only employers operating remotely can avail of that option, and that will expire in June 19th. Now, visa process, and during the pandemic, foreign workers might also remain in the US beyond their authorized stay due to like travel or safety concerns. And where applicable, they could or they should timely file an application for extension of stay and change of status, because USCIS announced that even if the processing of these forms gets delayed, applicants will be fined as long as they timely file these applications. USCIS may also excuse late applications if the delay was caused by COVID-19. Next slide, please. Okay. And employers with H-1B employees should know that there is what's called a no benching obligation, which means that H-1B workers cannot be furloughed, laid off, or paid less than the wage indicated in their labor certification. These have been triggered as grounds for denying H-1B petitions, so it's likely that USCIS will terminate the H-1B status if any of these occur. So the only option for employers is to terminate the employers after notifying the employees and USCIS, but then they'll have to bear the repatriation expenses. And this could also seriously impact the lives of the employees, of course. So this would be most likely to be a last resort. Now, employees on H-1B can work from home as long as their home office is within normal commuting distance, which is usually 50 miles within the approved work site. And again, for this to work, it is important to document that the employee will be working from home like an email or like a letter would do for that documentation purpose. Employees, this is pretty important right now, are advised not to leave the US, especially as the immigration landscape remains very uncertain with presidential proclamations, travel restrictions still pending, and we still might have a few more coming up. So they're strongly advised not to travel. And note on international students on OPT, if they accrue 90 days of unemployment after graduating, USCIS will terminate their work authorization. So employers planning to delay the students' start date should take this into account. Reduced pay is also not an option for H-1B employees. If employer absolutely must reduce pay, they could refile an amended labor certification, but that could be pretty onerous. And that's why there have been articles written about reducing pay now and making up for that difference later with a bonus, but this is very risky and is strongly not advised. There is also a temporary rule in place to help employers hire workers on H-2A, H-2B visas, which are for seasonal workers. For example, for H-2A visas, employers who have workers who cannot re-enter the US or are facing delays in their petitions can hire other foreign workers who are already in the US with a valid H-2A. There's another rule in place for H-2B workers. Employers can hire foreign workers already within the US with H-2B visas, even though their petition is still pending and not yet approved. And H-2B workers in businesses like food supply chain, like meat packers, can remain in the US beyond their normal maximum by having employers rehire them. These rules will be in place up until August and September of this year, so employers can avail themselves of this option until it expires.
Right, thank you very much, Hoon. And for everybody, thank you for being patient. I know we are a couple minutes over. David, if it's all right with you, I would like to just quickly run through the questions that have come up in the chat box.
You sure can.
All right, thank you. Because I think the questions that are being asked are probably on everybody's mind. So one question, who funds required COVID tests if I'm requiring those tests for my employees? Generally speaking, all COVID-19 tests are covered by health plans, health insurance. Nobody should be paying for a COVID-19 test. If any of your employees are in a situation where they have to pay somehow for a COVID-19 test, it would be upon you, the employer, very likely to fund that test. But COVID-19 tests should be free, and there are rules in place to make sure that nobody needs to pay for a COVID-19 test. So somebody asked, when asking employees to self-report temperatures, can we ask if they've taken ibuprofen, or just tell them beforehand, here's how you take your temperature properly, and not taking ibuprofen beforehand is one of the conditions. You could do either or both. I think it is perfectly acceptable to ask, have you taken ibuprofen in the last 8 hours? Just as you could ask, have you just come in from, being outside in the sun, anything like that that would affect the temperature? You can absolutely do that. And you can ask whether you're having employees self-report or whether you are taking temperatures when employees arrive in the workplace. Again, you're not gonna be able to do this for over the long term, but for right now in this pandemic situation, asking those questions to make sure that the temperature protocols are followed is absolutely acceptable. Does the employee using medical concerns need to provide a medical or doctor's note? You can absolutely ask for a doctor's note, both for employees who are coming to you with medical concerns, either to support reasonable accommodation or paid leave, or employees who are coming to you with medical concerns of family members. For example, I have to care for my mother-in-law. So you can absolutely ask for a doctor's note. You can't, review charts and all that sort of thing, but you can ask for a note from the doctor saying, yes, this person tested positive for COVID-19 on June 7th, something like that. Is making the ability to work remotely an approved accommodation? And then there's a related question, is there guidance for non-H-1B employees working remotely? Absolutely, working remotely is a reasonable accommodation. If your employees are able to perform their job functions, you can absolutely say, to stay on payroll, I need you to be working, but you can do it from home. That is going to be, for many of you, hopefully the easiest accommodation you could make, although it doesn't apply to all types of employees. But certainly I would recommend that. Again, we had a faculty meeting at Cornell yesterday, and one of the topics of discussion was to what extent faculty and staff are going to continue working from home. And certainly the guidance from the top of the university was for every department, do everything you can to facilitate your people working from home for as long as it makes them comfortable doing so. And let me see, I think that is it for the questions, unless there are any others, although I know that we are 5 minutes late and it's a beautiful summer day and everybody should get out in the sunshine.
I do see one more question.
I think L.E.A.R.N does.
Go ahead, Hoon.
I did see one question from Ali. Oh, okay.
Oh, thank you. I have to go to another Zoom. Sorry. Thank you.
No, not at all. Thank you so much, Ali. Thanks for the questions.
Thanks, Ali. It's always great to see you. If there weren't any additional questions, I'm gonna go ahead and wrap this up. In the event that someone who is watching this later has a question and would like to follow up, you can email me at dwalton@tompkinschamber.org, and I can get that information over to Celia. Or Celia, if you feel comfortable sharing your email, or I can just direct them to you, whichever you prefer.
Absolutely, that's fine. So yeah, so my email is cwb94@cornell.edu, or you could just, Google my Cornell faculty page. There's a link to my email right there. So I'm perfectly happy to talk to anybody else who would like to.
All right, awesome. So again, on behalf of the Tompkins Chamber, it's our sponsor, Tompkins Trust Company, Ms. Celia Bigoness and Hoon Lee and Cornell University, we would like to say thank you all for attending today. Be on the lookout for other webinars that we have coming up in our recovery and reopening series. And you guys just be safe and take care. All right, bye everyone.
Thank you very much.
Thank you, Hoon.
Thank you.
Bye.